Hello, everybody. Hope you're all having a good day and a good week. Happy kind of start of summer. My kids are finishing school this week, so it is officially feeling as if summer is starting. So I hope everybody is getting into the summer mode. Thank you all for joining me today. Hopefully you're in the right spot. We're here to talk about extraordinary ability visas. Specifically, we're going to touch on the O-1A option, which is for people with extraordinary ability in various fields, including business, science, athletics, education, basically anything other than arts and entertainment. That is and kind of motion picture and TV. That's the O-1B. So today we're going to talk about the O-1A. I did a separate presentation all about the O-1B, and that's available on our YouTube channel, so you can find that as well. And I'll touch on some O-1B things today, just when I'm chatting about requirements. So we'll kind of naturally distinguish O-1A from O-1B slightly. But the primary focus of today's presentation is going to be the O-1A visa. So hopefully you're all in the right spot. I'm going to just get started. Even if we can wait for people to, people can trickle in, and I'm just going to get started on this. So hopefully everybody can see my presentation. So I'm thinking that you can. Feel free to answer or to ask some questions. You're welcome. Somebody just said thank you. I'm not sure if people can see my screen when I pop those up, but feel free to ask your questions in the chat or in the Q&A. I will try to get to them as they come along, but sometimes I might just need to leave them till the end of the presentation. So let's get started. Okay, standard lawyer disclaimer here, that obviously this is not legal advice. It's general information. Watching this does not make me your attorney, and you really always need to get specific immigration advice from an immigration attorney in a private setting. Also, just keep in mind that this is a public webinar. So if you're asking questions, just know that everybody is seeing your questions. So don't put anything too personal. There's no confidentiality, obviously, in a chat on Zoom. And, we are recording the webinar, so we'll be making this available later. So just as normal, use common sense when posting things on the internet. So, some helpful resources, immigration policy is changing quite often. So different trends coming and going, different policy updates. We would encourage you all to follow us on our various social media handles. We're kind of on everything, including TikTok. So please follow us. It's US Visa Lawyer is me, McEntee Law Group. I think on TikTok I'm Immigration Lawyer Fiona, something like that. Anyway, you can also follow our blog online. We have a great email newsletter that goes out periodically with immigration specific updates. You can sign up for that on our website. First Fridays, this is when we do the first Friday of the month. We do a live update from an immigration attorney at McEntee Law. We kind of rotate around, and we are skipping First Friday in July because it's around the holiday, 4th of July, sometime in and around there. And we know people are kind of, on summer mode. So we're going to take a break for July. We should be back in August. So you can catch us then. And then obviously in between then on our various social media platforms. So O-1s, okay, these are, I think, a distinct practice area and somewhat of a niche practice area within immigration. And kind of what that means is that not everyone who practices immigration will have experience with the O-1 visa. Now, as it turns out, this is very much within my wheelhouse as an immigration attorney, and within our firm as well. We're kind of known for our work on the O-1 visa and the corresponding EB-1A extraordinary ability green card. A little bit about me. I came to the US as an international student, and very passionate about advocating for changes to immigration and updates that will be beneficial for immigrants. I do a lot of media work. So a lot of speaking and writing on different things. I also teach other immigration attorneys about the O1 and the EB1A option. I've led numerous panel discussions at our national immigration lawyer conferences. And I've just published my second book, which is US Immigration Options for Startups, Accelerate Your American Dream. It's available as an ebook on Amazon. And if you're thinking about startups, if you're an immigrant and looking at, moving to the US, or you're here already and you're thinking about how you may be able to stay here, I would encourage you to hope to get the book and read it. And I think you'll find it helpful. So it kind of goes through various options, including the O-1A. But there are some other comprehensive options that are discussed in the ebook. So check that out. It's available on Amazon as an ebook, and it will be available in print in the coming months or so. Okay, so this is just a little screenshot of me, my law school graduation, and kind of how it started. That is a picture of ice hockey. What I now know to be ice hockey. At the time, I didn't really know anything about the sport, but when I started my first job as an immigration attorney, I was picked to go pitch a major league franchise for the immigration services, and I went and gave a presentation, and we ended up winning that client as a client for the firm, and I became their lead attorney. So I became very used to working on P1s, O1s, visas that were connected to sports, and I also had been doing music cases in that firm. So that's how I got started. And then how it's going, this is a screenshot of leading the panel at the Extraordinary Ability Visa. This was from our National Immigration Lawyer Conference in Florida just before the pandemic. And actually we're going back to Florida, and that's a whole other can of worms there, but we're doing some advocacy surrounding immigration, and we have our national conference as well. And I'm also leading a panel on social media. So I do have a lot of experience in O1s, EB1As, and coming up 16 years of practice as an immigration attorney. So I've also done a lot of advocacy from a media point of view as well, which is kind of important, I think, as well, when you're thinking about O1s. Sometimes press comes into it, and kind of how do you leverage the press for your clients, and how can your clients leverage the press, and do you even need press? That's a question that we'll answer later. This is one of our beloved clients, Mert Naziri. He's the former CEO and founder of SwipeSense. His company has been acquired since, which is fantastic. It was acquired by SC Johnson and Company, but we started working with Mert when he was an international student at Northwestern. And since then, we brought him through O1, green card. He's left, his company was acquired. He's written a book called Exit Right, about exiting a startup. I would encourage everybody to read that. He's now teaching at Northwestern. He's just an incredible example of amazing immigrant entrepreneurs. And so I'd encourage you to check out his story. Here's another one of our clients. This was an O1B client, Yulia, a Russian artist. And we got her, her story was covered in the Chicago Tribune, and it was on the front cover of the Chicago Tribune. So there's a sample of that. Some more of our amazing clients there, some of which are startups. And so it kind of just gives you a sample of the types of people that we're working with. Here's our team. We are based in 2112, which is a big music and entertainment ecosystem. In Chicago, immigration is federal though, so we can work with clients all over the US, which is the beauty about working in a federal practice, that we have a national practice throughout the US. But 2112 is our home. I think there may be some people from 2112 here. So thank you for joining us. We also did a podcast, Immigration Revelation. The reason I'm bringing it up here is because Mert was featured in it, and some other people were featured in it that went through the O1 and visa experience as well. So you might find that interesting. It was a limited run podcast, Immigration Revelation, if you want to check it out. Okay, into the O1. Let me just have a quick look at the chat. Okay, so Liz is actually posting the link to the ebook and just giving some instructions about questions. Okay, so the O1 visa. How do you qualify for the O1 visa? So I like to describe this as the process as kind of needing to fill 3 different buckets of things. So I think it's helpful to think of it in this way. So bucket number 1 is that you need to prove that you have extraordinary ability in your field. And I would just say that sometimes the term extraordinary puts people off. Right. It can be seemingly to be bragging, or, it's some cultures, Irish people I will speak to because I know this, we're quite self-deprecating. And so the idea of calling yourself extraordinary would, make you seem like you have notions. And so it can be uncomfortable for people to think of themselves as extraordinary, but let's not be put off by the term itself. Let's get into what being extraordinary means for O-1 visa purposes. But number 1 bucket is that you need to prove that you are extraordinary in your field. Number 2 is that you need to have somebody to file the case on your behalf, and we'll get into how that would look for you. And number 3 is that you need evidence that you're going to continue working in your area of extraordinary ability, which is important because the reason you're getting the visa is because you have extraordinary ability in something. So, obviously we want you to continue to work in that field that you're extraordinary in and not do something different. And this can be an issue with people who are maybe going through some career transitions, think the athlete to the coach, or, the model to the startup entrepreneur was something that we encountered a couple of times as well. So, bucket number 3 is evidence that you're going to continue working in your field. So the good news about having an administration that, has specifically stated that they want to welcome immigrants to the US is that they have also made some policy changes that have been very helpful, including changing or updating the policy manual for the O-1A. Now, given my work that I do from an advocacy point of view, I have had meetings with the White House, members of the White House and the USCIS, which is the agency that adjudicates O-1 petitions. You'll see this here, the US Citizenship and Immigration Services, USCIS, about these options, right? And they have said that they want to create more certainty for people, and they want to encourage people to use some of these options, including the O-1A. So as a result of this stance, they made some statements surrounding welcoming immigrants, but they also put some meat on the bones of the law, right? Because we have the law that shows us like what is an O-1 and what is the criteria for the O-1. But fleshing out what each one of those criterion means, we don't really have that. But now we have this policy manual that really does that. So I obviously, maybe not everybody gets excited about reading government policy manuals, but I really enjoy reading the appendix to the O-1A, and now the O-1B has also been added. But this is the announcement, and then you can go on to the policy manual and you can see the appendix that goes through each criterion and tells you what you can use in support of it. So here's an example that I just pulled really quickly from this, right? So one of the criterion is awards. So awards or prizes for excellence in your field. So that's what the law says. Okay, well, what kind of awards? Can I use awards that I got in as a student? Do the awards have to be given to me? What if they were given to my company? So there's lots of questions that you would have when it comes to assessing whether or not the awards is something that you're going to use. And so here's an example of what the policy manual says in relation to awards. So it acknowledges that the majority of awards that you get as a student are not really going to rise to the level of recognition that's needed for the O-1A awards criterion. However, they do say that there are some PhD scholarships or dissertation awards that are nationally recognized and that would rise to the level of this criterion. And so they give you an example of, they kind of flesh out, we look at the criteria, we look at the national significance, the number of awardees, limitations on eligible competitors, And so again, a further example, like an award available only to persons within a single locality, employer, or school may have little national or international recognition, while an award open to members of a well-known institution may be nationally recognized. So meat on the bones in the appendix to the O-1 policy manual. We also got some updates to the O-1B policy manual, which came later, right? The O-1A ones came in January 2022, and we just recently have had the O-1B policy manual updates, but we also have those too. So that's kind of some of the changes that we saw. And here's like our McEntee law approach to O-1s, right? When we're thinking of this, we're thinking of the buckets, right? The first bucket number one, extraordinary ability in your field. So there's a couple of subparts to this. First, it's like, how do you prove extraordinary ability? And then second, what's your field? Okay, so let's think about the second part of this first. What is your field of expertise? Are you more in science, education, business, athletics? Are you more in the arts, which is very broad, or motion picture or TV, right? You probably know if you're in motion picture or TV, but it's not always clear when somebody's in the arts versus business. For example, we had somebody who worked in the hair and beauty industry who was very successful in their own brand of products and retail locations. But is that business or is that arts? You know, they're successful because of they are an artist in the hair and beauty industry. But is that a business success or is it more artistic? And so the answer to this that we argued was arts, and we won that case. But it's a question that we've definitely handled regularly. For some people it's crystal clear, but for others it's not always clear if it's O-1A or O-1B. So sometimes you need to kind of get into the meat of the case and the evidence and kind of determine that may give you some guidance about which category is more suitable to you. And there are some advantages to picking some categories over others. And as I mentioned, you know, I love this, keep calm because you're extraordinary, but humility is not your friend. You know, the self-deprecating kind of approach to things. And I think sometimes the more extraordinary people are, the more humble they are. So you'll find sometimes people with 30 years of experience can be, you know, put off by the O-1 thinking it's out of reach. And sometimes you have people who are relatively young in their career thinking that the O-1 definitely works for them. And it could, right? But it's just, I think the label can put people off. So this is a testimonial from one of our clients that I thought was important to include here. Now, she was in an O-1B because she was a documentary film producer. And we worked on her O-1 and it got approved. And she originally did think it was out of reach. And then when we started to dig into the option for her, it became apparent to me that she, I think, could put forth a strong case. And we did, and it got approved. So, you know, it definitely happens. Okay, so we're looking at the O-1A versus O-1B, and this is meant to, you know, this picture to give you an idea of that, like hair and beauty example, right? And we also had somebody who was a nightclub entrepreneur that I was originally thinking was going to be in O-1A because it was more business CEO type role. But then when we started to look at it, it became apparent that he was actually really creative in terms of curating lineups and designing like his venues in a very creative way. And so O-1B was better for him, and that also got approved. So within the bucket number one, the first thing is step one was like O-1A or O-1B. Step two is defining your field of expertise. So I kind of like this like term, this like Goldilocks approach, right? It's not like, what is it, oh gosh, it's been years since I've read Goldilocks. Too hot, too cold, like in between. You know, you don't want to be too broad with your field of expertise. Like I'm an expert in, or my extraordinary ability is like computers, computer science, or technology, right? Something way too broad. Or too narrow, where, you know, you're just in such a niche that there's really nobody else in your field. There was a court case where a judge mentioned that being at the top of a field of one is meaningless. And in the case, it wasn't literally a field of one, but the point is a very small pool. You know, being at the top of that is not really significant because there's just not that many people in the pool. So I guess in theory, easier to be at the very top. So you need to get it just right. And your attorney can help you work through this. And you could also, collaborate with your attorney to try to find out what is that just right? What is that Goldilocks for you in terms of your field of expertise? So the next is that we need to provide evidence to document your extraordinary ability. So we've figured out if you're O-1A or B, we have defined your field of expertise, and now we need to support it with evidence. So this is a photo that we took of an actual, it was an O-1B case for a fashion designer. I've put a video on my TikTok anyway of a request for evidence response for an EB-1A, so you can see what that looks like as well. But that's an actual representation of the case as well. So you can see the evidence that goes into an O-1. It's substantial. So how do we figure out what evidence to use and which boxes we're going to check for you? We'll get into what the boxes are, but we have a strategy meeting during a consultation normally, where we will spend about an hour talking through the criteria, trying to figure out which criteria we want, ideally 3, boxes to check. We're also maybe talking about, who your petitioner is going to be and what options like that. So kind of working through all the 3 buckets and figuring it out. Now, this is the tip from me, that I generally prefer to pick the 3 best criteria and only submit evidence for those. I have seen other attorneys, to their detriment, try to go for 5 and 6 and, just like a whole bunch of criteria. And I think it's a mistake, because I think that you, if there's one that's not as strong, it can just highlight deficiencies in the case. And I think it just, it would, the odd time we would go for a 4th. But you only need 3, and I think you're better to pick your 3 strongest, unless you really can't decide between 3 and 4, unless they're equally as strong. I think, one time we had a producer, and I think we may have done all 6 for the O-1B, or maybe 5, because we just couldn't figure out which ones to eliminate. But that's rare. Normally, I would say pick your best 3. So in the O-1A versus the O-1B, I mentioned that there were different kind of pros and cons to each. There is a lower standard for the O-1B. But that being said, I don't really know how that's kind of put in practice, right? It's still a high standard. It's if there's no point in trying to squeeze into O-1B, because the standard is slightly higher, when in fact you're an O-1A, because that would hurt you more than it would help you at all. But there are different standards, and there's different kind of rules in relation to support beneficiaries as well. Okay, so still on bucket number 1, proving that you're extraordinary. This is the O-1A criteria. So this is kind of what we're looking at when it comes to proving that you are extraordinary. And there's an list of 8 things here: awards, critical or essential role for distinguished companies, press, original contributions of major significance, high salary or significant remuneration, authorship of scholarly articles if you're in academic or research, membership in outstanding associations, or judging the work of others. It's important to note that you don't need all of these, as I mentioned. You need 3, or if you can't get 3, comparable evidence why these criteria just don't really fit with your field. But ideally you're getting 3 of these. And that means, like, you don't have to have press. If you don't have press, that's fine. You just won't be using press, but you need some other ones. What I think is helpful to do is to go through this list. And this is what I do kind of when I'm meeting with clients, and we figure out which ones are we definitely not going to use. Okay. If you're not an author of scholarly articles, you're not going to be using that. Okay. So we'll take that out. And like, it doesn't mean like writing like blog posts or like newspaper articles. We have fleshed out guidance about scholarly articles, like all of these. When I showed you the appendix earlier, that's the appendix fleshes out this O-1A criteria and the O-1B criteria too. So you can look at that for additional guidance about what does high salary or significant remuneration mean in the context of the O-1A. What we showed you the screenshot of the awards earlier, but what's critical or essential role for distinguished companies? Like, how do I document that? So we go through, we eliminate which ones we're not going to use. Like, you'll know, have you ever judged anybody? You know, you may have, and potentially you can use peer review stuff in for PhDs as well. That was also in the appendix. So, you know, you in the startup industry, a lot of times there are different judging, pitching competitions, hackathons, things like that. So you actually sometimes do have the opportunity to judge others. But if you haven't, you know, take that out of the equation. That's not one that you're going to use. So you start to get rid of the ones that you definitely are not going to use. And then you're kind of narrowed down to sometimes 3, sometimes 4, sometimes 5. And then you kind of go through with your attorney and figure out what evidence can I use to support these? Are there any that are more objective than others, like high salary? You know, we recently did that for somebody whose salary was substantial, and we could compare that to Department of Labour databases, right? Because high is only high if it's higher than others, right? That's a yardstick that you're judging by. So we have the Department of State or Department of Labour's like database for mean wages in certain areas and median and stuff like that. So we can look at that and compare it to. But this is what you are looking at if you're in O-1A. If you want to be in O-1A, you want to ideally have 3 of these to prove extraordinary ability. O-1B criteria, just because we mentioned them before. There's only 6, right? And you'll see some of them are slightly similar to the O-1A, like the high salary, the, you know, lead, there's again, a little bit different wording, but, you know, lead or critical role for distinguished companies. It's also written in the past tense and the future tense in the O-1B, expert recognition being a standalone category. So this is the O-1B. So slightly different. There's only 6. You need 3. And in the O-1A, there are 8. So we had previously asked for questions from O-1 webinars that I have done, and some of these questions came in that I'll just like touch on here briefly. I think I've kind of already answered some of them, but people say, how important are awards in my field? And in my case, I'm on national TV, but I haven't received any awards. So, and actually the next question was also kind of, the answer is kind of similar. Do I need much press? So if you recall, you don't need to have everything. You need 3 solid criteria, like criteria on each. You need 3 boxes to check out of the 8 if you're the O-1A. So, I mean, here, if you're on TV, probably you may be in the O-1B. So you'd be looking at those 6 criteria and trying to pick 3 of them. And, you know, we've actually worked with some pretty major influencers, massive influencers that don't have much personal press. Which is fine. They have other things that they can use. So you don't need any of these. They're not a prerequisite to getting the O-1. If you had them, we would assess them and see if it makes sense to use them, because not all press is good press. Not all is like sufficient for O-1. Not all awards are sufficient for O-1, right? So we would kind of assess whether or not that's your best, right? And if so, we would talk about how we can use it. So let me just have a quick look at the question. Okay, the O-1A, this is a good question here. How many awards, press, and judging would be enough? I'm going to answer this question live. Great question. I would say that it can be a quality over quantity type thing. So for example, but like, let's say press, I would love 6 to 8, like, good articles for you. It's not to say that you have to have that, right? There's no kind of threshold. But ideally, you're looking at national press, right? Wall Street Journal, New York Times, you know, we're looking at national press is better than regional press. And you can also use press in outside the US. It doesn't have to just be US based press. But the press also needs to talk about you and your work. So somebody came to us a while ago that they were in a magazine or some type of press, but they were just being interviewed about remote work or something that was not necessarily related to their expertise. So yes, they were in, you know, a piece of, you know, major press maybe, but like not really related to their work. For example, let's say I was interviewed by Elle magazine about being challenging, like, you know, juggling being a working mother, for example. But that's more really about the balancing my work with being a mom, and not necessarily about like, as an immigration lawyer, I have done X, Y, and Z, and about then the kind of significance of my work. So the type of press is important as well. And in relation to, let me look here, press, judging, again, judging would be the same. It would be like, how many competitions, what type of competitions, who are you judging? And so we would kind of assess more from a quality point of view. And same with awards. You know, if you've won like a really big award, like if you were on Forbes 30 under 30, which one of our clients was, you know, that's a really good, although they did try to push back and say that it was like there was a limitation on the award, and it meant because it was only open to people under 30, it wasn't significant, which we completely pushed back on and won. It's ridiculous. Like, most startup entrepreneurs are in that age bucket anyway. And so it's arguably one of the most competitive categories. But, you know, if you have some of those type national awards, they're pretty significant. So maybe you don't need a whole lot of them. Is there a way to see which O-1A applications get approved and which ones get denied? I believe they may have statistics about approval ratings. I'm not sure. Here internally, we have, you know, I don't want this to come across as a guarantee of approval, but I can count on maybe a finger or so how many O1s we've had denied in over the course of my career. But also, if somebody didn't have a hope in any, we wouldn't waste our time preparing an O1 case if we didn't feel like we could prepare a strong case. Although, having said that as well, we have done O's for people who are relatively early in their career. So it doesn't mean we won't kind of, you know, be creative as well and work with our clients. But I don't know, as far, you know, obviously cases are subject to like privacy when they're filed and the content of the case, unless you're involved in the case. And, you know, so I don't think you can review like samples of like approved cases, but an experienced attorney should be able to assess your case. And especially if they're familiar with your industry, to know, okay, in startup entrepreneurs, like TechCrunch is a good article, or, you know, Chicago Inno. And if we can look at Forbes, you know, they'll know the lingo and they'll know what type of evidence we're used to seeing, and be able to give you an assessment of your case, kind of based on cases that they have seen approved. I will also say that, you know, when a case gets filed, it goes onto a random officer's desk in the USCIS. So there can be an objective element to the adjudication, or sorry, subjective element to the adjudication. So it can come down to, you get an officer that is, you know, in a good mood and wants to, you know, and kind of gets what you're trying to do or what you do and is appreciative of it, versus the next officer could just be the opposite. So there is a subjectivity to adjudications, and that's why you really need to put the strongest case forward as well. Okay, these are good questions, so keep them coming if you have them, and I'll try to get to them as I come along. Okay, going to take a sip of water and then get into bucket number 2. So bucket number 2 is, you need to have a petitioner or a sponsor, an employer, somebody or an entity, some company needs to be filing the case on your behalf. So, you know, how do we figure out what petitioner situation will work for people? Well, this is an individualized analysis. Like, what is potentially on the table for you? Do you have a prospective employer? Do you have a company? Like, what are our options here? And like, what are your goals? You know, what do you ultimately want to be able to do? So we can kind of work through that and see, based on this, like who or what type of petitioner situation would work for you. So the potential options that anybody has are, have a direct employer-employee case. This is definitely the most type of straightforward O1, where you're getting hired by Google, for example, to be their, you know, CTO, okay, something like that. They are giving you, they're your employer. They're going to file a case as your employer petitioner. That's option 1. Option 2 is you can potentially set up your own company and have that act as a petitioner for your case. Now, we would discuss this with you in depth because there are some kind of nuances to know about this approach. The Foreign Affairs Manual, specifies that you may not self-petition for an O1 in your own right. So me personally, Fiona McEntee, can't file an O1 petition for myself. However, you can set up an entity, which is a separate legal person, right, and have that entity file for your O1. So you're not self-petitioning if an entity is filing on your behalf. But with that being said, we would, there are some things that need to be discussed in terms of who's going to sign the forms on your behalf. We can talk to you kind of about that and about like proving that you're going to have work in your area of extraordinary ability, which is bucket number 3. That becomes more relevant when you're setting up a new company, because, they're not going to, the USCIS is probably not going to push back to ask that Google, for Google to prove that you're going to work as, in technology as the CTO, for example. Obviously, there's plenty of work for the CTO of Google to do in his or her area of extraordinary ability. But where you have one of these, option 2 to 4, whether it's your own company, an agent petitioner, or other types of foreign employer, just different petitioner arrangements, there's going to be more scrutiny on proving that you're going to work in your area of extraordinary ability. So setting up your own company is one. Having an agent petitioner, an agent for foreign employer, I would say that we typically use these more in O-1B for bans and things like that. It's not to say that you can't do it in other situations, but I think just the takeaway is that there's potential flexibility with the petitioner structure, but note that you're not individually filing the case for yourself as an O-1. Okay, bucket number 3 is that evidence that you're going to continue working in your area of extraordinary ability. I'm just going to quick check the questions here while I'm, okay, I've done that. Okay, I'll come back to this. I'll come back to those questions at the end. So, okay, bucket number 3 is evidence that you're going to continue working in your area of extraordinary ability. So this is heavily connected to bucket 2, as I mentioned, like the Google CTO example versus like setting up your own company and having that be the petitioner. In the direct employer-employee case, you have a contract, an employment contract that shows the term of your employment, what you're going to be doing, your duties, things like that. In other types of situations, you will have maybe agency agreements, publishing deals, employment contracts with a foreign employer. You are not allowed to get an O1 for speculative employment. So that means you can't just request a 3-year O1 term, which is the most you can request, without showing what you're going to be doing. You do need some specifics. You may be able to have some flexibility depending on the arrangement, letters of intent to hire, things like that. But, you do need to show what you're going to be doing in your field. Some of these cases also do need to go through a union if there is a union involved. So the union gets a copy of the case fully before we file it, and the union needs to review it and make an issue what's known as a no objection letter. The unions definitely want to know what you're going to be doing, and so they will push back if you don't have clear evidence of that you're going to be working in your area of extraordinary ability. So this is kind of, the bucket number 3 evidence, and it is connected really heavily to the petitioner structure that you're going with. Okay, how long does an O1 visa last and what's the success rate? Okay, so O1 visas can be up to 3 years, but you do need to show work for the duration of the period requested. Success rate of getting accepted is, I don't know if there's a universally, available success rate, but I think there may be online, I'm not sure. But our rate is obviously quite high, as I mentioned, but again, can't be using that as an indication of any future approvals or anything like that. Someone's had asked, is it better to file an O1 from inside the US or outside the US? So this is just kind of a procedural question depending on where you are. Ultimately this is a petition-based case, so it does need to get filed with the USCIS, which is the Department of Homeland Security agency. If you're abroad, you're going to need to go to the embassy or consulate after the approval to get a visa stamp in your passport. If you're here, you may also need to do that. And in any event, when you travel, you'll need to do that. So there may be two parts to this process: getting the petition approved first, which was that big, massive case that we showed you. And then secondly, getting a visa stamp from the embassy. Okay, so like that's kind of the O-1A in a nutshell. There's obviously a lot of things to unpack. It is a very individualized analysis, but I'm hoping that these slides and this info is helpful to you as you think about the types of evidence that you're going to need, the requirements, and whether or not an O-1 is going to be suitable for you. There is a green card version of the O-1, which is the EB-1A green card. And just note that you don't have to go from O-1 to EB-1A green card. And actually, we just got one approved for somebody who'd never had an O-1 and actually applied from outside the US. And we got them an extraordinary ability green card. So you can do that. We've also done, EB-1A green cards for people in E2s, startup entrepreneurs in E2s or H-1Bs, and then went to EB-1As. So it's not a prerequisite to getting an EB-1A that you have an O-1 approved, but for some people, it makes sense to test the extraordinary ability waters, so to speak, with an O-1. And the reason it might make even more sense for people is the O-1 is a temporary intent visa to a certain extent, for the most part. And the green card is a full permanent intent visa. So if you apply for a green card, you're demonstrating that you want to be in the US permanently. And that may be an issue if it doesn't get approved, or if there's some additional hurdles. You may have an issue with temporary visas later on down the line. So for some people, strategically, it might make sense for them to test the O-1 and then maybe consider the EB-1A. Also, while you don't have to have the O-1 first and then go to the EB-1A, you also, an O-1 approval does not guarantee that you're going to get an EB-1A approved. So it's not a guaranteed approval. But it's obviously a good sign, but the standard's higher for the EB-1A. Some of the overlap is there's some evidence that's overlapped in the O-1 to the EB-1A. Some of those criteria are mirrored, but the standard's higher. Okay, so one of the things that we're going to offer is we're going to offer a special O-1 consultation offer for anybody who's watching this webinar, either live or at a subsequent date. So my hourly consultation rate for O-1 consults is $450. If you book a consultation with me or one of our other attorneys who have different consultation rates, we will credit the consultation fee to the attorney fee for the O-1 case. So we don't normally do that, but we will do that for people watching this webinar. Our website enables you to book a consultation directly. You can see the time, you can see the consultation agreement, you can book, pay, do everything. We try to be as tech forward and savvy as we can, maybe not as much as all of our clients who are doing incredible, innovative things, but we try to make things as easy as possible with different time zones and everything. So you can book a consult directly online. Upcoming events, we have our first Fridays. I mentioned that we're going to take a pause for July. So we will be doing our next first Friday in August. So you can join us then. Webinar Wednesdays, which is what this is. Thank you for joining the Webinar Wednesdays. There's another one next week. I think Natalia is doing the K1 fiance visa. Catherine has previously done a marriage-based green card webinar, so you can see that on our YouTube channel. Ray did an O-1B for musicians, so that's a webinar that you can also check out. I've also done the O-1B for like influencers, bloggers, artistic people, creatives. So you can check that out. I've also done an international entrepreneur parole, which is an exciting option for startup entrepreneurs. So a whole bunch of webinars that you can see that will be helpful as well. Here's our contact info, email, website, all the usual kind of ways to get in touch with us. Okay, let me stop sharing my screen. So I'm going to check the Q&A now. So hopefully everyone is here. Okay. The first question, well, I've answered 2 live. So another question that we get is their aim is to get an O-1 as soon as possible. A lot of people want things, obviously want them as soon as possible, but it is O1s do take time to build up evidence, right? Because you can see that case is not done overnight, so it takes time. So they also want to transition into a different role from QA to project manager within the IT industry. Is that likely? Is it likely to significantly lengthen their time to establish her O1? They want to take some time to establish themselves in a new role. Okay. So this is a bit of a career transition question. So they're working as a QA and they want to move to product manager. So the first thing I would say is like, what visa are you on right now? Are you in the US? And if so, if you're not an O1, which I'm assuming you're not because you mentioned that you want to get an O1 as soon as possible, you need to think about any changes to your job with your existing visa and how that might impact your existing visa. So that's the first thing you need to think about. Then as far as like how this career transition will impact your O1, you do need to prove that you have extraordinary ability in your field and that you're going to continue to work in your area of extraordinary ability. If you're trying to get into a new field, it's going to be hard for you to prove that you have extraordinary ability in that field. So, that's going to be something that you're going to have to think about. If you've already been working for many years in one particular role and you think you can satisfy the O1 with that, then maybe you look to do that and then figure out how you could maybe add in some of the product manager duties. If it's broad enough to encompass some of those, perhaps you may be able to draft the job description to encompass some of that as well. We did something similar for an O1 client who was in like a director of engineering role and kind of was moving into like partnerships, but also still kind of leading the IT team. And so it may be possible to structure some type of overlap between the roles, but you would definitely need to get some specific advice there. Because like you're getting an O1 because you have extraordinary ability in your field. Okay, so someone's saying, do they take into consideration the plight of the employers from a rural area, small business, retiring owners? Is about the applicant? That is not really, unfortunately, a consideration in the O1. It is very much based on the individual. However, there's a national interest waiver green card case, which talks about it's more about the impact of the work on the nation, right? So it shouldn't be as regional, it needs to be more like a broader impact. But in a green card like that, it's more about the work and the future work and how it's going to kind of benefit other people. So slightly different type of focus. But for the O1, it's really, is this person extraordinary? So unfortunately, like that wouldn't be a part of the analysis. I'm just thinking if there's a small business, somebody's retiring, if perhaps there's an opportunity to sponsor the person for a perm processed green card where you do recruitment and show there's no qualified workers available, that's a part of that type of green card. So there may be some other options there. It may be that the person qualifies for an O1 and then the additional considerations are just additional considerations, but they're still meeting the O1, evidence, criteria, requirements, but we just have to see. Okay, two last questions. Can one jump from F1 to EB1A? I love this question, and potentially yes. However, we would definitely want to talk to you because have you spent enough time in your field that you have solid evidence to go to extraordinary ability green card EB1A from F1? F1 students after graduation get a year of OPT and then potentially 2 years of STEM OPT work extension. So you may have 3 years of experience. You may also have prior experience prior to your F1. It is entirely possible to do. Strategically, do you want to take that risk? Not sure, right? That's a good example of maybe it might make sense to test the extraordinary ability waters with an O1 first to see, are you O1 level of extraordinariness? Like, are you meeting at least the O1 standard? And if so, then how do we springboard up to the EB1A? So I would like to strategize with you about you know, moving from F1 to EB1A, and to see whether or not you'd have enough evidence and whether there's any risks, right, to trying to just go straight for the EB1A. So we would see, but that would become an individualized type analysis for you. Okay, another final question that we're getting is, can I explain the ways startup entrepreneurs can prove extraordinary ability? Yes, I certainly can. And this is something that is very much in my wheelhouse. I work with startup entrepreneurs all the time. Okay, so remember that for the O-1A, there's the 8 boxes that you can potentially check, and you want to check at least 3 of them. So ones that I typically use for startup entrepreneurs: press, right? If the startup has gotten press, the founders are generally named in the press and kind of given credit for the you know, the whatever the success or the traction or the fundraising, things like that. So press. If you've been accepted into any prestigious accelerators, we could maybe use that as memberships and associations. If you've ever judged other startup entrepreneurs, that could be a way that you can show that. Original contributions of major significance. That is something that is ripe for startup entrepreneurs, because there's so much originality, innovation, whether you have a patent or not, you know, you're probably doing something original. And if so, then that might be one you can use. Leading or critical role with distinguished organizations. That's one that I use all the time for my startup entrepreneurs. So I think that actually the O1 evidence, the O1 criteria really, really nicely fits for the startup entrepreneur. So I think that, again, maybe not somebody like immediately the minute they founded their startup. Obviously you need to get some traction, but if you've raised any funding, VCs, maybe we can, you know, we can definitely use that in support of maybe even more than one box. Sometimes you can use one piece of evidence to check multiple boxes. So that would be a question that I would like dive into with you to see what evidence do we have for you. I think that you would also find my ebook helpful, because I talk about you know, other options for startup entrepreneurs, including the O1. The International Entrepreneur Parole is a relatively recent option for startup entrepreneurs that have received US-based funding, including venture capital funds, angel investors, accelerator, you know, grants, kind of awards from accelerators, or government grants. So that might also be an option for people. So, you know, I think right now we are working with an administration that is, you know, at least on paper and policy, wanting to be pro startup entrepreneur, pro O-1A. They've updated policy manuals, they've taken steps, they have updated mission statements. And we use all these things in support of our cases. So it's a good time to be thinking about these options for everybody. And so I would encourage you to think about it, right? If you feel like the O1 might be a good fit for you, to contact us so we can give you one of these personalized assessments and see. And I mean, we're going to be honest with you. Sometimes it's hard to tell people that the O1 isn't going to fit for them, and we can't guarantee it, right? But we can go through and say, okay, we have these 2 solid boxes that we can check. The 3rd and 4th, we're not sure which one is stronger, or we're like, we just can't see a 3rd has happened before, or we're just, you know, not finding enough to really file the case. Because we do need some hefty evidence to support the O1. But they're fun cases for us to work on. Our team loves these cases. And we just love seeing our amazing O1 clients be able to be in the US, contribute, give so much to the US. And we're so lucky as a country to be able to attract people like that here. So it's definitely a big passion of ours, is working with people on O1 visas. Hopefully that came through today. And I hope this was helpful to you. I really appreciate everybody tuning in. The webinar will be recorded, so we'll make it available on our YouTube channel. Okay, one other question. Last question, Taylin. So someone's asking about EB5. So we would have to talk to you separately about that. It's not really a topic for the O1 webinar. But if you have specific questions on EB5s, you can please feel free to email us at info@McEntee Law, and we can talk to you about a consultation for that. So yeah, just to conclude, thanks everybody. Hope you all have a great rest of your day. Look forward to connecting with you online. If you find that this was helpful, I would hope that you can share it with some other people that might find it helpful. And yeah, Thanks for the support, and I look forward to seeing you online and maybe in real life as well. So thank you all and have a great day.